Hi there, it's Mohammed Razak. Uh, it's a great opportunity for me to be here. I'm a master's student at Soran University and participate in this conference with an article. So I have prepared a presentation about this article. If you just let me, I'll share with you this article and talk about it in detail. So this one is the article itself, and I want to share with you the notions of my article in detail, but not like comprehensively. Will not be shared with you because of the time. And the title is Modernizing Civil Liability Rules for Damages Arising from AI-Generated Works. So let's talk about this in detail. I will focus on civil liability and AI-generated harms that we linked, and we searched for the interfaces and interconnections between civil liability and generative AI. We have compared two different jurisdictions into each other. I mean, EU, European Union, and Iraq are both main jurisdictions that have been compared in my article. And as you can see, that the main problem, as we will be about, is that the current civil liability doctrines are inadequate and insufficient to be to address and tackle the issues regarding AI generative works. So as I said, the problem statement is very clear, and we say that the content of AI generative AI's content is like in these days harm and let's say causes harm to people, and when something like that happens, we have to resort to the courts and pursue the rights and responsibilities. In that cases, we see that mainly in those cases, in those jurisdictions, mainly dependent upon the fault-based regimes. I mean, the heavy burden of those of proving the fault is upon the shoulders of victim, and the victim should prove the three pillars uh, uh, of liability, as we will be about. So proving fault and causation is very, very difficult in cases like, I mean, regarding AI generative words. So why? Because we have many types of characteristics that AI has, and were not available in the past when the laws were issued. And those legal issues, like we see that autonomy, I mean, unpredictability of AI, we don't have any information how it decides, how it creates contents in itself, and opacity, the black box problem, as we see. So another main problem is the multiple parties that are available, involved in this process. So as I said, that the civil liability in itself has three pillars: the victim, and I mean the concerned parties, or those who are victims out of the acts of generative AI, should prove three pillars of AI, of civil liability, sorry: fault, damage, and causal link. Three pillars are very difficult in terms of AI because, as I've said, AI has its own unique characteristics that are very, very difficult to be proven. So liability approaches compared, as I said, that EU, when you look at the jurisdictions and compare them to each other, you see that EU has updated its legal framework for AI to tackle and address the issues that have already been risen, and they have issued in 2024 an enacted Artificial Intelligence Act, but does not necessarily specify the rights and responsibilities of the parties and concerned, let's say, victims and the defendants and plaintiffs. So PLD is previously issued law in on on the scale of European Union, but they have recently been about to amend it in order to bring in a new mechanism into it in order to tackle the issues of algorithms and software as a comprehensive issue. But when we return to Iraq, we don't see any efforts to tackle the new issues, rising issues like AI. We still depend on civil liability, civil code, which has been issued in 1951, and main focus of this law is on fault-based regime, that the victim should prove the full the three pillars of liability. So therefore, we see that no specific regulation in Iraq is available yet. Therefore, we are obliged to depend on the already, let's say, the previous mentioned, like those mechanisms that have been mentioned in the law. In civil law, we have many different methods to apply: vicarious liability, product liability, legal personhood for AI, analogies like animals or tools. Whether we should say that the AI, generative AI, is like a human, therefore we will personify it and give it the rights and responsibilities like what we do with our own rights, like a natural person or juristic person. Then this is a very heavy, let's say, controversy on this, and not yet been dismissed or decisively, let's say, decided about. Each one of these points have its proponents, and in the same time, people or authors are there that they are against it, applying it because of the unique characteristics of AI. So we have many case studies, and these 3-1 are very popular to be returned to if you just need it and read about it. Regarding reform proposals, we see like the civil legal regimes should be more specifically talk about AI. Currently, we have to issue laws specifically regarding AI in order to regulate the new, current arising issues of AI. So mechanisms are available right now in European Union. We can benefit from them, like rebuttable presumptions of fault and causation, mandatory insurance schemes, whether it is like an old mechanism, but it has been updated lately by European Union Commission. So transparency and obligations for developers. It's one of the another mechanism on the shoulders of those companies that should present their best in order to be very, let's say, transparent and clear for those who want to return in the case of needs. So in conclusion, we see that the takeaways, let's say, traditional rules are outdated. Not even outdated, but they are. We need new system of dealing with these cases, because it's not only an abstract provision to tackle these issues. We have to have a staff to deal with this. While we derive laws, we have to depend on the very professional staff in different aspects of life, especially technology. I mean, regardless of let alone they are legally, they have legal backgrounds, but we need those who are very deep in their information about technology, and they are inventors of AI, in order to derive the provisions of law correctly. And also, legal modernization is essential. As I've already said, the title of my article is that modernization is very important. And if that modernization is harmonizing, then it is way better because when you see that the entire world have gathered on one table and discussed like with a convention, discuss these issues and modernize the rules regarding this, then we will not be in front of the like fragmentation of rules and judgments of the courts. I mean, we will not be in front of the fragmentation of verdicts of the courts. Therefore, I highly prefer and highly recommend to have that kind of system internationally harmonized and not, let's say, standardized. Thank you for your listening. Thank you for your time, and have a great time.